Let's kick right over to this question from Mike in North Carolina. It goes, first of all, Happy New Year. Thank you, sir. Happy New Year, you too. He says, I am about to fill out and appear for my mandatory in-person appearance here in North Carolina. I looked up the online registration requirements, and I have a question for you or Larry. Trust me, it's not for me. In section B, it talks about commercial social networking. I've read it multiple times. That's him reading it, not me. Does it mean sites like Registry Matters? Not sure if I even fall into the high-risk offender portion in section C1. I'm going to report in person on Monday, hoping someone can take a look at it.
Well, someone did take a look at it.
Who did it?
I followed his link, and I got the statute, and I plopped it in here, and we have a licensed attorney in the state of California, so that would qualify for North Carolina, don't you think? We could.
I think so.
If I want to malpractice somebody, it does. But go ahead. Go ahead.
So
take a shot.
So we have. So looking at the statute that he provided us, and just looking at the definition contained in Section B, and it's very crucial that Section B says that meets all of the following requirements to be covered. And since I'm such a horrible reader, if someone would like to read 1, 2, 3, and 4, but I'm having my doubts that Registry Matters would qualify for those for all of them combined, because it can't be any one of them, it's all of them.
All right, well, I will read them. It says, it is unlawful for a high-risk PFR to do any of the following online. So 1, to communicate with a person that the offender believes is under the age of 16. Number 2, to contact a person that the PFR believes is under the age of 16. Isn't that the same thing? It believes, to communicate, to contact. Isn't communicate the same as contact?
Yeah, you're in Section A, though. We were.
Yeah, you want to skip down to B there.
You didn't. Okay, well, you said 1, 2, 3, 4. All right, so here, sorry, back up. Section B then says, we're going to come up with the definition of social networking websites. So here's one. Is operated by a person who derives revenue from membership fees, advertising, or other sources related to the operation of the website. Now, you told me in pre-show that this would be a true, but we don't run it here locally. It's run through a third-party site. So does that make this not count for us?
Well, I think it would be one of the 4 possibly met, but then we've got more to go here because it has to be all of them.
Okay, and then number 2 is repealed by Session Laws 2019-245, Section 3A, effective December 1st of 2019, and applicable to offenses committed on or after that date. Number 3, allows users to create personal web pages or profiles that contain the user's name or nickname, photographs of the user, or other personal information. I don't think that applies. Like, you could leave comments on the Registry Matters website, but like, that's not a way for you to like be in contact with each other. And then you said number 4, so provides users or visitors a mechanism to communicate with others, such as a message board, chat room, or instant messenger. And that one's a hard no.
We don't do number 4.
I mean, again, if you left a comment, someone could reply to your comment, but like, that's not communicating with. I wouldn't really call it that.
So.
Yeah, though, this is a very gray, all these things, well, with the exception of number 1, all these things are pretty gray.
And if, in my opinion, and this is only an opinion of an individual, but in my opinion, these 4 are not met. All 4 of them have to be met. Not really clear on number 2, but I don't think all 4 of these are met in terms of this. But when you say something's in a gray area, then it gets into a rule of lenity, right, Chance? When you have something that where there's a lack of clarity, any doubt and ambiguity is supposed to be resolved in favor of the runner, the accused. And so therefore, this seems very innocuous. I would be very surprised if he had any problems with it. But one never knows.
Yeah, one question that arises, and you're looking at 3 and 4, is whether, Does this include Discord? Use of Discord?
I mean, that would be significantly closer to meeting these things. People don't create profiles. They sure as heck communicate with each other.
So
yeah, that's what I'm talking about. That's why I'm saying it's kind of gray. This is what makes it gray for me, because I don't know whether or not Discord would be included in all this.
Certainly.
well,
And then I asked you this also, and someone just in chat said, I thought the Supreme Court said it was unconstitutional to block us from social media.
well, they did say that in Packingham. That was a total ban. But they didn't say that there couldn't be reasonable restrictions that are narrowly tailored and targeted. The problem for the lawmakers, and I know that thousands of them listen across the country, you can do almost anything if you narrowly tailor it. If you put your broad brush into the dumpster, and you will figure out a small subset of the total PFR population, there's almost nothing that you couldn't do. But you just can't help yourself because you listen to the victims' advocates and to the law enforcement apparatus too much, and you don't think about how to narrowly tailor it. I can think of ways you could narrowly tailor and get away with almost everything that you'd want to do, but that doesn't give the satisfaction of being able to pontificate that you're being tough on all the registered offenders. That just doesn't sound as well when we've got, it's kind of like our three strikes law. When we had a Gary Johnson as governor in the 1990s, he insisted that we should have a three strikes law. And we passed one to satisfy Governor Johnson. Not a soul has ever been in 30 years given a life sentence under our three strikes law because it's so narrowly tailored that you could, I mean, Nolan Ryan could not have hit that strike zone when he was in his heyday of being a great pitcher. I mean, it's impossible, but you can do a lot of stuff if you narrowly tailor.
If you look at it, I think they've attempted to do that. I mean, just look at the title: Ban Online Conduct by High-Risk Sex Offenders That Endangers Children.
You've
They're
been listening
banning
to F. Why?
You know, of course, this gets into social media, but, you know, the idea is that they're trying to, to nail it down to a very, very small and high-risk segment's conduct. So this, it just goes into the mix in making this gray.
But if you look at subsection A and the 1, 2, 3, 4 there, again, you would needed to have narrowly tailored it even below what they've got it tailored here, because you might have a biological child or someone you have legal custody of, and you're telling them they can't communicate with any person. It doesn't say. And if you want to do this correctly, you will say, except for, and you would put those exceptions in there of biological children that you have legal custody of, and so forth and so on. But they didn't do that.
Right.
The contact person,
I mean, so we're talking about different shades of gray.
Mm-hmm.
Do you want to be the person who has to litigate that is the question.
Mike, we need you to be our crash test dummy on this one.
Yeah, I think
see how he responds to that.
I think he's
here.
I think he's not excited about doing that. That's why he put this
probably
in
not.
But
he said no.
I don't think he's got anything to worry about. But if you look at the punishment down in section E, a violation of this is a Class H felony. Now that sounds like a lower level felony in North Carolina because they probably go A through H, maybe for even further. But still, it's a felony offense, and that could possibly subject you to a lot of incarceration time if they can use it as habitual enhancement and all these kind of things. It could be a very uncomfortable situation.
Not to mention just at least even going to the county jail to be processed before you go off and do the rest of your time. Even if it's 3 months, it's enough of a pain in the butt.
So.
All right. Did we cover everything?
As best I know how to do, and Chance, or you agree that it's a bit iffy, but I don't think he's got any potential threat coming his way. But you never know.
Yeah. No, I'm. It's a bit iffy and gray to me, and I'm not sure I'd want to be the crash dummy on that. But choices.
Well, I mean, he's here on Discord too. I think the conversation is about, is he able to like download the podcast from the website to listen to it? Couldn't that immediately collide with First Amendment of being able to receive information with the information to redress grievances with your government, et cetera, et cetera?
It certainly could.
Yeah.
But again, does he want to be facing a $50,000 bond for a PFR if they try to make an issue of this?
I think he's independently wealthy, and I don't think money's an issue. And I'm just kidding. I know he's going to like rage type at me. No, again.
You've been listening to FYP.